California habitability laws explain for landlords what you're legally required to maintain. Habitability is one of the areas of California landlord law where you really can't afford to be fuzzy, because a habitability issue isn't just a maintenance problem. It can become rent withholding situation, a repair and deduct situation, or in serious cases, a legal action against you. And the part that surprises most landlords is how much California's definition of habitable actually covers. It's not just the obvious stuff. I'm Candace. Let's go through what it actually means to keep a property legally habitable in this state. What California law says a habitable unit requires. California Civil Code 1941 defines what a landlord is legally required to provide. The list is more specific than most people expect. Effective waterproofing and weather protection, working plumbing and hot and cold running water, adequate heat, and in California, adequate heat means capable of maintaining 70 degrees in the main rooms, working electrical systems, clean and sanitary premise, free from infestations, working smoke detectors and carbon detectors where required. Here's what a lot of landlords miss. The standard applies to the condition you hand the unit over in, and it applies throughout the entire tenancy. So you can't hand over a unit in great shape and then let it deteriorate. Maintenance failures that go unaddressed long enough can create a habitability issue even if the unit was fine when they moved in. California's definition of a habitable rental is more specific than most landlords realize. Here's what it covers. Under California Civil Code 1941, a habitable unit requires working plumbing with hot and cold water, effective weatherproofing, adequate heating, working electrical systems, clean premise free of pests, and functioning smoke and carbon detectors. The standard that surprises most people is adequate heat means capable of maintaining 70 degrees in the living areas. A unit with a broken heater in January is not legally habitable. That's not a repair request. That's an emergency. And the obligation continues. The property has to stay habitable throughout the entire tenancy, not just at move-in. Response time and the legal clock. Once a tenant notifies you of a habitability issue, California law starts the clock. How much time you have depends on the severity. So for emergency conditions, no heat, no hot water, sewage backup, gas leak, the expectation is that you respond immediately. 24 hours is a practical standard most courts would apply. For serious but non-emergency conditions, 30 days is the general rule of thumb. Minor issues have more flexibility, but I'll get to that eventually. It's not a legal standard. The documentation piece matters here. When did the tenant notify you? How? What did you do? When? If you responded within 24 hours and coordinated a repair the same week, you'll want to be able to show that. If the tenant later claims that you ignored the habitability issue, your timeline of documentation action is going to be your defense. How long does a California landlord have to fix a habitability issue? The answer depends on what it is. Emergency conditions, no heat, no hot water, sewage backup, those require immediate response. The practical standard courts apply is 24 hours, not this week, not when it's convenient, that day. For serious but non-emergency issues, the general limit is 30 days. For minor repairs, there's more flexibility, but there's no legal standard that protects, I've been meaning to get to it. The most important thing that you can do is document when the tenant notified you, what you did and when. That timeline is your protection if the situation ever escalates. Handling maintenance legally. There's a difference between a landlord who has a maintenance problem and a landlord who has a legal problem. The difference is usually documentation and response time. When a tenant submits a maintenance request in any form, acknowledge it in writing, even if it's just a quick text back that says, got it, getting somebody out this week. That creates a record. Then follow up in writing when the repair is scheduled and when it's completed. The repair and deduct situation is what you're trying to avoid. Under California law, if a landlord fails to make a repair in a reasonable time after being notified, a tenant can hire a contractor and deduct the cost from the rent, up to 1 month's rent. It's not common, but it's legal. But the landlord who gets there is usually the one who quit after the maintenance request and left the tenant with no visibility into what was happening. Communication is key. the landlord mistake that leads to tenants legally deducting repairs from rent, and how to avoid it. California's repair-and-deduct law allows a tenant to hire a contractor and deduct costs from rent, up to 1 month's rent. If a landlord doesn't make the repairs in a reasonable time after being notified, the landlord who ends up there almost always made some type of mistake. They went quiet, the tenant submitted a request, didn't hear back, followed up, still no response, and eventually just handled it themselves. Acknowledge every maintenance request in writing, even a short message saying, "On it, getting a contractor scheduled." That one habit prevents the biggest majority of repair and deduct situations. What makes rental legally uninhabitable? There's a specific legal status a property can reach in California called substandard conditions under Health and Safety Code 17920.3. This is the level at which a tenant can legally withhold rent, or the city can get involved. The conditions that get you there aren't always dramatic. Dampness and water damage that's been reported and ignored, faulty weather protection, inadequate ventilation, infestation that the landlord has been notified about and hasn't addressed, lead-based paint that hasn't properly been disposed. The pattern is almost always the same. A condition exists, the tenant reports it, the landlord doesn't respond effectively, and the condition worsens. That accumulation, especially when there's a paper trail showing the landlord was on notice, is what creates legal exposure. The condition alone isn't usually the problem. The response to it is. What does it actually take for a California rental to become legally uninhabitable? More common than you think. A rental becomes legally substandard under California Health and Safety Code when conditions like water damage, inadequate weatherproofing, infestation, or faulty utilities go unaddressed after the landlord has already been notified. Notice is the key word. A condition that the landlord knows about and doesn't fix is treated differently than the ones they didn't know about. The paper trail, the maintenance requests, the follow-ups, the dates is exactly what determines legal exposure. Most of the serious habitability situations I've seen were preventable. The condition wasn't catastrophic at the beginning, it just got there because nobody responded to it effectively. What tenants can legally do when a landlord doesn't maintain a habitable property. Landlords should understand this. California tenants have 3 main legal remedies when a landlord fails to maintain habitability: repair and deduct, rent withholding, and constructive eviction. Repair and deduct is capped at 1 month's rent and requires proper notice. Rent withholding requires that a tenant place rent into an escrow, not just stop paying. And constructive eviction is when the conditions force a tenant to leave and they sue for damages. None of these are easy for tenants to pursue, and most tenants don't want to, but a landlord who's unresponsive long enough can push a situation to the point without meaning to. Response time and documentation are the best prevention for all 3 of these habitability issues. Habitability law isn't meant to be a trap, it's a standard. And it's a standard that's actually not hard to meet when you have good intentions and systems in place. Respond to maintenance requests promptly, document everything, and address issues before they accumulate. If you have any questions about what's required for your specific property or a situation that you're navigating, I'm happy to help be a resource. See you in the next one.